Rise. 14A District Court of the County of Washtenaw, State of Michigan is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presides.
You may be seated. Mr. Ganatra.
Morning, Your Honor. My name is Ganatra, Senior Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to wait for conflict on the court on the Office of the Public Defender. Prosecutor's Office does not believe the conflict exists, but if it's present, we waive it for all the cases in our office and the Public Defender's Office before this on the court. Thank you.
Thank you. Mr. Brown.
Good morning, Your Honor. Lauren Brown, Deputy Public Defender. We likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, waive that conflict so that this honorable court could hear these matters. Good colors, good colors.
Thank you, Mr. Brown. The court, for its part, also does not believe there's a conflict either in Michigan court rules or the cases decided thereunder. To the extent a conflict exists, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus CEDRIC Grigsby.
Good morning, Your Honor. Assistant Public Defender Jay Bellinger on behalf of CEDRIC Grigsby.
Andrew Childers appearing on behalf of the people, Your Honor.
Could you state your name, please?
CEDRIC Grigsby.
Thank you. All right, what are we doing?
Your Honor, we've had an opportunity to speak with Mr. Grigsby this morning, and I am advised that there was a very serious medical situation that is the reason that prevented us from contacting Mr. Grigsby. So that said, I would just ask for a 2-week adjournment so that I can properly meet with him and go over the discovery.
That objection, probable cause is adjourned to July 25th.
Thank you.
2024, 9 a.m. Bond is continued. Thank you, sir. Court calls case people versus Michelle Martinez.
Good morning, Your Honor. Ryan Bowling, Assistant Public Defender on behalf of Ms. Marinez.
State your name, please.
Michelle Marinez.
Thank you.
Your Honor, I spoke with Ms. Marinez yesterday at the prison facility. We'd request an exam be scheduled on this matter today.
You spoke with who?
I have it as Marinez, M-I-R-I-N-E-Z.
It is Marinez, you're right. Okay, thank you. And so you're requesting what?
An exam, please, Your Honor. Scheduling of an exam.
Discovery is complete.
To my knowledge.
People have their witnesses available the 23rd. I don't know if we're going to need a writ, so we're going to need at least 2 weeks out. It's going to have to go to the 30th. People have their witnesses available the 30th.
I believe so, yeah. Thank you.
Preliminary examination will be set in person July 30th, 2024, 9 a.m. That is before Judge Fresh Hour.
Thank you, Your Honor.
Bond continues. Thank you. Court calls the case people versus Demetrius Peters.
Good morning, Your Honor. First Assistant Public Defender Kalina Anderson with on behalf of Ms. Peters, who should be here from the Wayne County Jail.
Pardon?
Who should be here from the Wayne County Jail.
Yes, Ms. Peters, could you state your name, please? Mr. Peters.
My name is Diana Peters.
All right. Thank you.
Your Honor, I was unable to make an appointment to meet with her at the Wayne County Jail prior to today's date. We have an appointment scheduled for tomorrow at 4, if we can have an adjournment for that purpose.
All right. 2 weeks out, 25th.
Yes.
Probable cause conference will be adjourned July 25th, 2024, 9 a.m.
Thank you, Your Honor. Ms. Peters, we'll meet tomorrow, okay?
Okay, thank you.
All right.
Thank you. Court calls case people versus Robert Drobanchevsky.
Just one chair, people. Assistant Public Defender standing in for Mr. Lauren Brown.
All right. Your name, sir?
Robert Drobanchevsky. Good morning, Your Honor.
Thank you. Good morning. What are we doing?
I don't even know what's going on, ma'am. I didn't even know I was coming here.
Okay.
They pretty much denied me talking to an attorney the whole time.
Okay. Your Honor, at this time, we would ask for an adjournment. Make sure we can talk to you.
Just the only thing holding him? July 25th, 2024, 9 a.m. Bond continued. Thank you, sir.
Thank you, Your Honor. Have a
Thank
nice
you.
day, sir.
You do the same.
Thank you.
Just a minute, talk.
Thank you.
Court does call the case. People versus John Coleman.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Coleman. Who's coming up to the podium?
Your name, sir?
John Coleman.
Thank you.
You're asking for an initial adjournment to review discovery.
Probable cause conference, July 25th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the people versus Elizabeth Hill.
Edward Lucas on behalf of Elizabeth Hill in matter ending in 1172.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Hill in the other matter ending in 1172. Or sorry, I
You
misspoke.
both can't be. The other matter ending in 1459.
1459.
All right. And your name, ma'am?
Elizabeth Hill.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment today. We're working on a resolution. I think that one could be done. And with an adjournment, we can facilitate that.
How much time do you need? Probable cause conference, July 25th, 2024, 9 a.m. in both matters. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Let's call the case, people versus Jameson Mitchell.
Edward Lucas on behalf of Jameson Mitchell. Your Honor, at this time, we'd like to waive our preliminary examination. I've gone over that form with him. He understands that he has a right to a preliminary examination. We're waiving that today.
All right, sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir. Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over on counts 1 through 4 with 5 following. Mr. Durkis.
Your Honor, we acknowledge receipt of the information. We stand mute, waive reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea to all 5 counts. Pretrial in this matter will be set for
July 24th at 1:30 before Judge Conlon.
July 24th, 2024.
July 24th, yes.
July 24th, 2024, 1:30 before Judge Conlon. Bond will continue. Thank you. Let's call the case of the people versus Zachary Kratz.
Morning, Your Honor. Uwe Dowsaping with and on behalf of Zachary Kratz, who's standing to my right. Zachary, please state your name for the record.
Zachary Kratz.
We're here for public cause conference, looking to adjourn the same for discovery. We're still waiting for a number of forensic reports. I understand. I have no idea how long that might still take.
Can you hear me over here, Your Honor, or should I step in?
No, we can hear you. Those mics are on.
There is a Google return that Mr. Doss has been communicating with Ms. Willenbring about. It contains several hundreds of images of scam. So Ms. Willenbring said he's gonna have to go view that at the police department. So that is done. There are others outstanding, but we don't object to an adjournment.
How much time?
I was looking for at least 4 weeks. I understand there's several devices with Michigan State Police still pending analysis.
Yes.
Probable cause conference, August 8th, 2024, 9 a.m. Bond continue.
As to bond, Your Honor, we did make a request, I think submitted it in writing for today. It is for a modification of Mr. Kratz's condition to not use the internet. He's of college age. He has applied to Washington College. He was able to do this in person, but now that he's been accepted, he's been directed to enroll and sign up for the WCC portal, which I think requires internet use, and we request that he be permitted to do so.
I don't think that is appropriate based on the nature of the charges, Your Honor. We requested that at the time that the defense was arraigned. And I'm sorry, did you file a motion, Mr. Dawson?
I don't have a motion.
No, it's not a motion. I think I submitted a request or a proposal to Ms. Willenbring, and then I submitted it to the court, and I believe it was placed in the court file for the court to read.
Well, I have that, but
we're not.
All I have is that she's not agreeing to change the bond in this case. I think I would need a written motion before me that can be responded to so that I can see exactly what you're requesting, if it's just solely for educational purposes and if there's a way of limiting it. But I would agree, given what I at least initially see, that unlimited access to the internet's not going to happen.
Oh, that's not the request, and I will put.
I understand it's not the request. I'm just saying, based upon what I see, I understand why the people have their position. I'm just saying that if there's educational purposes, I need to know the specifics of that. And then we can try to maybe figure out something.
And I will put it in motion. Very good.
Thank you. Bond continued. Court calls case People versus Tolbert Smith.
Edward Drucas for Tolbert Smith, who is approaching, Your Honor.
Your name, sir?
Tolbert James Junior Smith.
Thank you.
And Your Honor, today's time and date set for a probable cause conference. I was appointed yesterday to the matter. I did provide the discovery to Mr. Smith. There is some video that I do need to go over with him. I'm asking for an adjournment today to go over that.
Probable cause conference, July 25th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Sandia Anderson.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I called her name. I didn't see her.
Sandia Anderson.
Oh, come on up. I called you before and you didn't answer.
Your name?
Sandia Anderson.
Thank you.
Your Honor, Mr. Ganatra and I did discuss this matter. There are some issues that we need to talk about and also with my client. So we're going to be asking for an adjournment. 2 weeks.
Without objection, probable cause conference, July 25th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case of the People versus Leo Stringa.
Not for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who is approaching. Say your name for the record, sir.
Leo Stringa. I have before me plea forms. Is that what we're doing?
Yes, Your Honor.
All right. In case 1425, plea form indicates that the defendant would be pleading to an added count, pleading no contest to an added count 2, retail fraud in the second degree. Upon a successful plea to that charge, count 1 would be dismissed. In that matter, the defendant is agreeing to pay full restitution. And there is a global plea agreement, which includes entering a plea in the following cases. And they're 242-265 SM, 15th District. I'm assuming that's 15th District Court cases. It says 15th cases. And then 220362 SM and 22363 SM with dismissals on cases 23158 SM and 2111223 SM. And it is the same agreement, although different offenses in the other matter.
That's correct, Your Honor.
That's the court's full understanding of the agreement.
That is correct, Your Honor.
May I have, has he signed the advice of right?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Leo Stringa. Sir, you understand that you're going to be pleading guilty or pleading no contest to 2 counts of retail fraud second degree. Yes, Your Honor. All right. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Let me explain 2 things about a no contest plea. Make sure that you understand.
Okay.
First thing about a no contest plea is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
Any other questions regarding a no contest plea?
No, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, to the charge of retail fraud second degree as contained in case number ending in 1425, how do you plead?
No contest.
To that same charge as contained in the case ending in 0962, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed an advice of rights form, is that correct?
Yes, it is.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5, that you should see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
I'm sorry, I didn't hear.
You're giving up the right to appeal of right.
Oh, yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
The court has been provided Pittsfield Township Department of Public Safety reports for their case number in 1452, their report number 21-13324. And in the other matter, their case number 21-7885. Any objection to the court having reviewed those reports?
No, Your Honor.
Based upon a review of the report in both those matters, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2 in each case. Count 1 is dismissed in each matter. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
July 24th at 9 a.m.
July 24th, 2024, 9 a.m. That is before me. Bond in these matters will continue.
Thank you, Your Honor.
Thank you. Oh, what I did was court does call the case of the people versus Darian Crystal. Darian Crystal. There he is. Go ahead, sir.
David I. Goldstein, appearing on behalf of the defendant.
All right. What are we doing on this case?
Going to be setting it for an exam, Your Honor.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 23rd.
Your Honor, I'm going to be out of the country on the, I'm sorry, out of the state on the 23rd. I'm available the 30th or the first week in August, either one.
People have their witnesses available on the 30th.
July.
Yes. I do see it.
Which judge is that on the 30th, Your Honor? Do you know?
I'll get to that in a minute.
Okay. Your Honor, I am aware of the A bond violation. I did discuss it with the tether agent. Mr. When the court's ready.
Okay, go ahead.
Okay, Your Honor, I'm aware that there was a violation, alleged violation, that he was in the exclusion zone. In that situation, Your Honor, my client contacted me, said he wanted to get some property from the location where he was excluded. I told him he could do a civil standby. Civil standby. He did contact the police. He went to a location, waiting for the police to arrive. And before the police arrived, the tether people apparently violated him.
Well, there's that issue, but then I also have that his tether strap was cut.
It wasn't cut, Your Honor. It was damaged. He had the tether on when the agents arrived, and it was replaced, and he still has it on.
But it was split from the bottom. Why was that?
He was doing something with his pants, Your Honor, and may have accidentally done it, but it was not intentional. In fact, and as I said, he was on when they got there.
I get that, but what could he have been doing with his pants that caused the tether strap to split?
I was trying to cut a hole around it for more comfort on my ankle, and I accidentally
Cut a hole around what?
my pants. Put a hole in my pants so I can get more comfort.
He was trying to cut around the tether.
Trying to cut around it, but now I just put my pants through it instead of going over it. And I accidentally cut the tether on accident when I was cutting a hole in my pants, trying to cut around it. This part. It wasn't like I was trying to cut it off or nothing. It wasn't that.
You were trying to cut a hole around the tether and you cut the strap.
Well, it didn't, Your Honor, you say cut. There was damage to the strap, but it wasn't cut off.
Okay, if you want to play word games, I'll play word games. I'm looking at the report. It was split from the bottom, so it was cut.
Yes.
It wasn't cut off. I get it. Or it didn't come off of his leg. I'm just trying to figure out how you cut the strap when trying to cut a hole in your pants.
Put my pants over it.
You're cutting with a knife?
Yeah, I used a knife to cut a hole in my pants. I wasn't trying to cut it off though. That was not my
Any response from the people?
work that out first and contact the tether agency before he did that. I mean, this is a domestic violence case guy that at the original arraignment, so there's its whereabouts.
Well, is there an indication that the civil standby was called for?
Yes.
I don't have any of the information.
We can get that from the police department, Your Honor.
Yes.
Who did he call?
Uh,
The sheriff's department?
Sheriff's Department. And it was Ann Arbor though.
Pardon?
It was Ann Arbor. I called Ann
Which
Arbor.
department did you call?
The sheriff's, the non-emergency line.
Okay, the Ann Arbor Police and the Sheriff's Department are two different agencies.
It was the police though.
The Ann Arbor Police?
Yes.
So you called the Ann Arbor Police Department? got a
Yes,
civil
before I
standby.
left. Before I came out here, I did that.
What?
Yes, before I left out from my house, I did call. I made that call before I left. And they told me to just give them a call when I get to Ann Arbor.
It comes from Flint, Your Honor.
Yes, I don't stay out there.
And did you call them?
Yes.
What date?
Whatever the date of the violation is, Your Honor. It all happened in one day.
So the tether cut was on the 28th at 1:34 a.m. Then the next day on the 29th at 7:30, they received a call that the defendant was in the exclusion zone, the monitoring center. The defendant drove through the exclusion zone, passing the victim's residence twice. Once the defendant became stationary, they contacted Washington County Metro Dispatch and they arrested him.
Now, Your Honor, I realize there's an
No,
exclusion.
no, hold it. I get that, but if he's got a civil standby and he's telling me he called the county, the moment Metro Dispatch is called, they're going to know that he's there. I need proof that there was a call for a civil standby because my problem right now is I've got what appears to be a tether tamper on the 28th, and then I have him in the zone on the 29th.
With the tether on, Your Honor.
Yes.
Okay. I'm still not understanding this whole knife thing, but he's in the exclusion zone and I don't have proof of a civil standby because that usually will appear very quickly. There would not be a violation file.
Your Honor,
So I'll tell you what, I'll pass the matter. You guys need to get over to the sheriff's department, get that information on the civil standby, and I'll call it back up. But if I don't have proof of the civil standby, then we're gonna have a problem.
All right, thank you.
Court calls the case, People versus Noah Williams.
We're ready in this matter, Your Honor. Lauren Brown, Chief, and they're appearing on behalf of Mr. Noah Williams. All right, today is the date and time set. Conference. The last report we have is that evaluation is still in progress. Not have an updated report at this time.
And that was the June 7th.
That's right.
Indicating, yeah, that's the last I had. All right.
3 weeks.
Well, they're delayed. I was trying to push these out a month and then move them up if we get it.
Okay.
So I think what I'll do is I'll go to August 15th.
It's actually,
Oh, it's not the 15th.
no, it's
The
the
13th.
13th.
Okay, August 13th.
All right.
That's a Tuesday, but it's August 13th, 2024, 9 a.m. And then if we get it earlier, we'll move the hearing date
Thank you.
to another day. All right. Bond continue. Thank you.
And Your Honor, for the record, I always wear bell bottoms with my tethers.
What'd you say?
I was always wear bell bottoms with my tethers.
Yeah. Maybe you should publish that so that others understand that. I don't know how you do that and not cut your leg, but I don't know. I had to cut holes in my pants for ages. Court calls the case, People versus James Jones.
That is also Mr. Goldstein.
That's Mr. Goldstein.
Yes.
All right, I'll pass that one. Busy at the sheriff's department, I'm sure.
That's also Mr. Goldstein.
Oh, yeah, they're there. Court does call the case of the People versus Sean Burrows.
On behalf of Mr. Burrows.
Please state your name.
Sean Burrows. Okay, thank you.
Your Honor, we're requesting a preliminary exam.
All discovery is complete.
To my knowledge, Your Honor, yes.
And would the people have their witnesses available the 23rd?
Your Honor.
Pardon?
Is that in front of Your Honor? This is an exam that we started in front of.
In front of me, oh, right. Okay, I see.
Your case was already set for exam.
So, well, it'd have to then be on, so it's another the 30th.
No, you're just keeping the same charge.
I understand.
Okay.
My next available date's the 30th that following week, so that's.
Thank you, Your Honor.
So I'll set the preliminary examination, July 30th, 2024, 9 a.m. before me. On other cases, got it. Bond continued. Thank you.
No. Nope, everything's the
Okay,
same. We
man.
just got another day.
Here.
Mhm.
Court calls the case, People versus Joel Awushu.
Should be.
Good morning, Your Honor. Deborah Sclosso on behalf of the defendant, Mr. Joel Owusu. Mr. Owusu, please state your name.
All right, what are we doing?
Your Honor, my client has immigration issues involved with this case, and I am in continued plea negotiations. I just spoke with his immigration attorney. I'm in continued plea negotiations with the prosecution. We're trying to figure out something that will lessen the effects on his immigration status. And beyond that, we're also waiting on a total restitution amount. So I would ask, Your Honor, I do believe this matter will be resolved, that you adjourn this matter. And the 25th, I have a trial in Monroe, so I cannot do that day.
Assuming no objection from the people.
That's right.
August 1st. Probable cause conference, August 1st, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the case, People versus Taquan Cowan.
First Assistant Public Defender Queen Anderson with on behalf of Mr. Cowan, who's approaching.
Mr. Allen, who is that at Ann's window? Is that somebody from the PD? Attorney? Okay, not properly attired, but okay, I understand. Go ahead,
Did you need me to do something, Judge? Oh,
unless you have a jacket and clothing for someone. Go ahead.
Your Honor, I've had a chance to speak. I'm sorry, Mr. Cowan, can you put your name on the record? Say your name.
Taquan Cowan.
Thank you, sir.
Your Honor, I've spoken with the prosecutor about this. It's my understanding that the investigation is still ongoing on this and that there may be additional charges. Based on that, I'm asking to adjourn the probable cause conference for that purpose. I would defer to the prosecutor as to the length of time required. And then I'd ask for the opportunity to address this bond.
There was an additional forensic interview done on Monday, so if that should be submitted, and I would anticipate having that charge next week. So
The chart. Got it. So 2 weeks out. All right. So probable cause conference, July 25th, 2024, 9 a.m. On briefly.
Mr. Bond, this is the only matter that's holding Mr. Cowan in custody. Case to me, he does not have any prior criminal history. He's concerned about his housing. He's unsure whether or not rent has been paid, or not he still has a home at this point. He's retired. We did go over the bond conditions of the no contact and no ghost. He would be able to abide by that. I've spoken with his sister and confirmed that he can reside with her in Detroit while this matter is pending. Mr. Cowan does suffer from some medical issues as well, kidney stones. He also has an inflamed colon and those services at the jail, and he is receiving Motrin, but that's really not helping with the pain. He's asking for the court to reduce the bond. Currently, his bond, I believe, is $100,000. That's a bond that he's not able to post. He has been in since June 26th. He does have the support of his family, which I believe some of his family members are here in the courtroom in support of him. We understand that the court's unlikely to give him a personal bond, but he's asking if the court will reduce the bond or at least allow a 10% privilege on the bond that's currently set.
Response.
And Your Honor, we would ask that the bond continue until the time of preliminary exam. There are 8 minor children living at this residence. The victim, in this case, in addition to another minor child, have been interviewed. And at the time that CPS came to the residence, the allegations when CPS was called out to the residence for the allegations of sexual assault, the defendant had nowhere to go. And he was left in the residence to be, only have supervised visit with these 8 minor children. The victim in this particular charge case is 9 years old, and the allegations are that he rubbed her so hard in her vaginal area while she was in the shower that he scratched her and she was bleeding. And so I believe he is a danger, not only to the community, but to these children. The 12-year-old, one of the 12-year-old boys that was interviewed said that he watched pornography on a regular basis with his dad, observed his dad having sex with his 14-year-old sister. So I think the allegations are very serious, and we would ask that the bond continue until the time of the preliminary exam when that is set.
And the new or the forensic evaluation, does that involve someone different than
A different victim, another minor child.
another minor child other than the one in this one?
Your
All
Honor,
right.
may I address part of that argument?
Sure.
Your Honor, the prosecutor stated that at the time he didn't have somewhere to go. As I stated to the court, he does now have somewhere where he can go and stay with family. It's also my understanding that the complainant in this case was taken to the hospital and that the allegations were not substantiated. I'm expecting the prosecutor will be providing me with copies of medical records to show that.
In which?
In this case, the original
In
case.
this case,
Yes.
then I have potentially either a new case or other charges coming regarding another child.
For understanding.
Bond conditions contain this, but indicate that there should be no third-party contact.
That it indicates that. So, but based upon that there are other charges coming, I get, Ms. Anderson, what you're saying, but the court at this time is going to deny your motion for bond reduction. Bond in this case will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Adelia Leslie.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Leslie. Good morning, Your Honor.
Morning. Ms. Leslie, can you state your name, please?
Adelia Janine Leslie.
Thank you. I have before me a plea form. Is that what we're doing?
It is, Your Honor.
The plea form indicates that the defendant would be pleading guilty to the charge of use of a controlled substance. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
Correct, Your Honor.
That is correct.
All right. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Adelia Janine Leslie.
Ma'am, it is the court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine or a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
Understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're also giving up certain other rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, not at the moment. I'm still incarcerated in MDOC till 2026.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
July 3rd, 2023, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, state of Michigan, did you have Suboxone in your possession?
Yes, Your Honor.
Did you have a right to possess that Suboxone in any way?
No, Your Honor. No, Your Honor.
All right, you knew what you had was Suboxone,
Yes, Your Honor.
and had you used it?
Yes, Your Honor.
All right, counsel? Have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. This is my case. Any objection to proceeding to immediate sentence?
No, Your Honor.
No, Your Honor.
Ma'am, is there anything you want to tell me before I impose sentence?
Now I'm on the MAP program and I'm not using that any longer other than in the program, and I'm doing counseling as well, Your Honor.
All right. How long have you been in?
The program I've been in for 2 months now, and counseling
No,
I've been
no.
in for.
How long have you
Oh,
been in
okay.
custody?
For 3 years.
Thank you. Fines and costs of $125, the state minimum fees on this. And then 365 days incarceration, credit 365 served. Okay, thank you, ma'am.
Thank you, Your Honor. You have a good day.
You do the same.
Thank you, Your Honor.
Court calls case of the people versus Zachary DeGeorge. DeGeorge. So which ones were David's back? These weren't in custody. I don't think. Your name, sir?
Zachary DeGeorge.
This is Mr. Brown's case.
Yeah,
Just tell me, don't worry.
You're ready.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. DeGeorge. Mr. DeGeorge, state your name for the record.
Zachary DeGeorge.
All right, what are we doing?
Your Honor, today is the date and time set for the probable cause conference. This is a matter that we are working on a misdemeanor resolution. We will need what are we good? A 2-week adjournment. We need to supply the prosecution with the information about Mr. DeGeorge's status. And once we have supplied them with that, we expect that a misdemeanor offer will.
July 25th, 2024, 9 a.m. bond continued. Court calls case people versus Marha Kasham. What? That was one of David.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Your Honor, we're going to be setting this matter for preliminary examination. I do have all the videos and we're ready to proceed.
You said the 23rd you were available?
No, Your Honor, the 30th or the 30th. First week of August.
People could have their witnesses available the 30th? All right. Preliminary examination in person, July 30th, 2024, 9 a.m. That is before
Fresh hour.
Judge Freshour.
Thank you, Your Honor.
Thank you. Bond continued. And court calls case Kimberly Farley or Parley? Farley?
With
Mr.
Freeze, Erica Julian appearing on behalf of Farley in 23 F11702 FY, which is an attorney general case.
And Assistant Public Defender Hannah Apple appearing on behalf of Ms. Farley in two cases, 5238 and 5536.
Those may be under the name Robinson, Your Honor.
Yes.
Oh, we have an AG here.
Yes, Mr. Freeze.
Oh, Mr. Freeze.
2 cases. That would be 23, 5238, or 5536.
All right.
23, 52. No. There's another Robinson.
Got it. Okay. What are we doing?
Thank you, Your Honor. I just accepted this case yesterday. I'm in preliminary receipt of discovery. I need to be able to review that with Ms. Farley. We're requesting an adjournment.
And we're requesting an adjournment as well, Your Honor, to work out potential plea negotiations and discuss.
Any objections from any of the people as to an agreement? What, 2 weeks or 3?
2 weeks, Your Honor, please.
Probable cause conference, July 25th, 2024, 9 a.m. In each matter, bond will continue in these cases. Thank you.
Thank you. Thank you, Your Honor.
Court does call the case people versus Brian Finnerman.
That AG is on Zoom.
Now I have the AG that's on Zoom. All right, I got it. That's what was throwing.
Yeah.
Can't hear you, sir. Hello? Go ahead, try it again. Whoa, something's not quite there because I'm not quite picking you up. Coker. Try, say it again. Now, something's, it's breaking up. It's going in and out. If you want to log off and sign back in or whatever, I'll hold it here. When I see you come in, we'll call it. Okay. Court calls the case of the People versus Kayla Garcia.
My name is Senior Assistant Public Defender working on behalf of Ms. Garcia. Ms. Garcia, would you please state your name for the record?
Kayla Garcia.
Your Honor, Ms. Garcia was accepted into the mental health court. We are still pursuing negotiations as far as what the plea will be for her to move forward. We'd ask for a short adjournment in order to accomplish that.
July 25th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
I don't have anybody right there. You got Gray or no? Court calls the case of the People versus Tashia Cobb.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Cobb, who is approaching.
Your name?
Natasha Cobb.
All right. Is she signed an advice of rights form?
Yes, she is signing it right now. Sorry. Your Honor, Ms. Cobb has just.
I have a substitution of attorney.
Yes, Your Honor, Ms. Cobb has just informed me of that.
All right. Well, we're
Walking in.
counsel, is this your client? Or we'll sign the substitution of attorney. Hey, what are we doing on this case?
She's taking the plea.
The plea?
Yes.
She signed it with advice of rights form. Yeah, I have a sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Natasha Cobb.
I don't need this, because that's going to be their copy. All right. Ma'am, it's this court's understanding that you're going to plead no contest to the charge of improper possession of a firearm in a motor vehicle. Is that correct?
Yes.
All right. That is a misdemeanor punishable by up to 90 days and or $100 fine plus court costs.
Okay.
All right. You do understand that the court's understanding after your no contest plea is that count one, the possession of a taser would be dismissed. Do you understand that?
Yeah.
All right. Do you understand what a no contest plea is?
Yes.
Two things about a no contest plea I have to make sure that you understand. The first thing is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Basis for the no contest plea?
This plea was negotiated by a previous attorney.
No, I know. I need a basis for the no contest plea.
This is, well, there is another matter going on with a PPO court, and we just don't want this to come in because it was alleged in that matter that.
Civil liability.
Yeah, civil liability.
Thank you. All right. And ma'am, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshauer in the 14A3 District Court. You understand that, ma'am?
Okay.
You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead no contest to this charge?
Yes.
And to this charge, how do you plead?
Guilty.
Well, I don't think so.
No contest.
Thank you. Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. Have you signed an advice of rights form today?
Yes.
Do you have any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole?
No.
Has anybody promised you anything?
No.
To get you to plea? Any other than what's been stated here today? Anybody promise you anything else?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
Court has been provided and has reviewed Northfield Township Police Report for their case number 242669. Any objection to the court having reviewed that?
No objection.
No objection. No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Satisfied.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
August 20th at 1 p.m. before Judge Fresh Hour.
August 20th, 2024, 1 p.m. before Judge Fresh Hour. Bond with its conditions will continue. Thank you.
At 1 o'clock.
1 p.m.
1 p.m. Yeah.
Thank you.
Thank you. Court calls the case People versus Nathaniel Gray.
Mr. Sinatra for the people.
Good morning, Your Honor. Maisie Berger requesting permission to practice pursuant to Michigan Code 8.120.
Code?
Michigan Rule.
Court rule.
Court Rule 8.120 under the supervision of Mr. Jay Bellinger, representing my client, Nathaniel Gray.
Permission to practice is granted.
Thank you, Your Honor.
All right, what are we doing?
Your Honor, we are requesting a 2-week adjournment so that we may consider continue going over discovery.
Probable cause conference in this matter will be adjourned July 25th, 2024.
Thank you, Your Honor. May we address bond?
Yes.
Thank you, Your Honor. Your Honor, my client is seeking a lower bond if possible. He has 3 kids and another on the way. My client would like to continue working if possible so that he may continue to provide for his family. He has the support of his family. He is a church-going man and he would just like to continue being supported by his family. He is willing to do an alcohol tether if need be so that he may continue to work while being monitored by the courts. I did want to note that he is being held on a probation violation in the 22nd. But
what's his bond in that case?
I waited until I finished with this to figure out what I was going through with this.
He's only been arraigned in that matter.
Pardon?
He's only been arraigned in that matter.
Okay, so what's his bond in that case?
I have no bond right now. I'll go Tuesday.
So it's no bond?
Right now, yes, sir.
Okay. So how did he come back into custody on this matter? Because he failed to appear back in March of 2024.
I got stopped.
You got stopped, so he didn't turn himself in?
No, Your Honor.
Anything else?
No, Your Honor.
Bond reduction denied. Bond will continue.
Thank you, Your Honor.
Oh, okay, he's back. Okay. Court does recall the case People versus Brian Finnerman. No, hold on a second before you guys come up. Judge Coker, I still don't have you. I can't. I have no sound at all. And everybody was with breathless anticipation waiting to hear your voice. All right, you might have to get another device because I can't. It's worse than before because you're not even showing up as responding when you're responding. I'm not. The box isn't lighting either. So I don't know what's going on. All right, I'll pass it. Do you have another?
Yeah.
Oh, you're keeping them together. Okay. Court does call the case of the People versus Peter Heenan.
Good morning, may it please the court. Jackie Mossford on behalf of Peter Heenan. Your Honor, today is the date and time set for a probable cause conference in the matter. At this time, I would request an adjournment of the probable cause conference so that adjournment until such time that Mr. Heenan can complete some substance abuse treatment. Having spoke with Mr. Heenan, I'd like to apprise the court that Mr. Heenan has previously voluntarily enrolled himself in inpatient treatment. He feels that he has acquired the tools necessary to maintain sobriety. He has a support system. However, they are not local, but he does have an extensive support system. He's indicated that this experience of being in custody over the last week, he's described it as rock bottom, and it's been literally and figuratively a sobering experience for him. We would ask that the court release Mr. Heenan to an intensive outpatient treatment recovery program. Obviously, Mr. Heenan would be willing to wear a scram tether, be subject to any additional testing and any meeting requirements that the court saw necessary. In the alternative, the court had previously discussed inpatient treatment, and I do have an update for Your Honor regarding those. regarding Bear River. When we were last here, the court ordered that CMH conduct an evaluation of Mr. Heenan and issue a referral to Bear River. Having spoke with CMH yesterday, they informed me that Mr. Heenan was not eligible for an evaluation because he has private insurance. I did speak with Bear River. Bear River informed me that they could conduct an over-the-phone intake assessment of Mr. Heenan, but they wouldn't be able to have a bed for him until 7 to 14 days out. Liberty House was the other inpatient facility. Liberty House does take Mr. Heenan's insurance.
Where is that located?
Liberty House is located in Fenton, Michigan, Your Honor. They accept his insurance. They have a bed that would be available tomorrow. They are able to do a phone intake as well.
That's inpatient?
Yes, it is, Your Honor.
How long is the anticipated program?
Both Bear River and Liberty House, their standard programming is 4 weeks. At the conclusion of such, they assess the patient's status and make a determination if a longer stay is necessary.
How would he get there?
Both Bear River and Liberty House would be able to pick Mr. Heenan up from Washtenaw County Jail.
So Liberty House would pick him up from the jail?
Correct, Your Honor.
All right. Any response from the people on that issue?
Yeah, I'm just obviously concerned, given the nature of the circumstances. He already he was out on bond. We had originally asked for $50,000 bond in this case, and he had a chance to be out on bond, and he drank during that time. If you are gonna release him, we're asking for him to be inpatient.
I went through a rather lengthy hearing the last time, so I'm aware of all of those things. How long an adjournment did you want?
If your honor is leaning toward the inpatient, I'd say at least 45 days out. That would give him time to complete the 30-day treatment, unless 30-day plus if there's an extension.
Well, Liberty, right? That would be, when would he get in?
Tomorrow.
He could get in tomorrow.
That's my
and be in
understanding.
a bed tomorrow.
Yes, Your Honor.
So I'll modify his bond. He can be released to inpatient, and the full name of the facility is
Liberty House.
Liberty House in what city did you say?
Fenton.
Fenton, Michigan.
And I'm glad you mentioned the bond, Your Honor. As in my conversation with Liberty House, they informed me that as long as the treatment was listed as a bond condition and not a court order, that would facilitate insurance potentially paying. Insurances sometimes refuse payment if the treatment is court ordered.
I'll indicate that can be released there. However, prior to his release, he needs to be on a scram tether. And I will put this over. Well, we'll do it this way. We're just gonna go to August 13th. If he's not out, then we'll figure out something, but I'm not gonna go too far out with this gentleman. August 13th, 2024, 9 a.m.
Okay, thank you, Your Honor. And just so I'm clear, regarding the scram tether, that's going to be installed today, and Mr. Heenan will be released.
We'll make sure to get him a tether.
Okay, you're going to get him the tether, and then will he be released?
He'll be
from
released
custody?
on a PR.
Okay, and then Liberty House will can pick him up wherever.
Yes, he must be released to Liberty House.
Okay,
Liberty House will pick up.
got it.
20,000, 10% bond.
Oh, he already did.
Yes.
Then I revoked it.
Right.
So it was 20,010 that he put. Okay. So I'll reinstate. He posted a 20,000 10% bond already. So that will go back. Is actually that he's already posted.
Okay, thank you, Judge.
Thank you.
Oh.
Okay, he's here. Oh, there he is. Okay. Court recalls the case, People versus Brian Finneran.
Good morning, Assistant Attorney General Emmanuel Wuta Coker, behalf of the people.
Yay, everybody's happy now. Mr. Finneran here. Oh, there. Go ahead.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Finneran. Your Honor,
Finneran, can you state your name, please?
Brian Finneran.
All right.
it's my understanding that Mr. Finneran is going to be waiving his right to a preliminary examination today.
All right. Is that correct, sir?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Correct.
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive their right?
Yes, Your Honor.
All right, preliminary examination having been waived, defendant is bound over to circuit court on both counts.
On knowledge receipt of the information, waive formal reading, my client stands mute.
Defendant have waived formal reading, standing mute. Both counts, court will enter a not guilty plea. Pretrial will be set for
August 21st at 1:30 before Judge Conlon.
August 21st, 2024, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond continued. He has another.
Yeah.
Is this? The CAG.
Yes, sir.
Court does call the case People versus Richard Nordell.
Good morning, Assistant Attorney General Emmanuel Wuta Coker, on behalf of the people.
Good morning, Your excuse me. Good morning, Your Honor. Brian Bowling on behalf of Mr. Nordell. Mr. Nordell, can you state your name, please?
Richard Nordell.
Your Honor, unfortunately, I haven't had the ability to be in contact with the Attorney General's office, so I don't have any discovery in this matter. I would ask the court to consider a brief adjournment so that I can follow up with the Attorney General's office and my client.
How much time did you need, Count?
2 or 3 weeks, I think, should be sufficient, Your Honor.
Probable cause August 1st, 2024.
Thank you.
9 a.m. Bond will continue in this matter. And it doesn't, so that the AG knows, it doesn't look like the bond has been sent over yet. But I do have the receipt here indicating that he did post.
Okay.
Okay.
Well, thank you, Your Honor. First, can I just get defense counsel's name? I think I have
my
one.
first name with a Y, and my last name is spelled B as in boy, O-L-L-I-N-G as in George.
Okay. Thank you. And Your Honor, if it's possible, the people would request that Mr. Nordell's bond be transferred to a support case in the meantime.
Yes, that was actually ordered. We tried to set a process in place that the bond is to be sent immediately over. So it was ordered by the magistrate on June 14th, but I don't see that it's necessary. Do you see it being sent? Pardon?
It doesn't appear sent over yet.
Okay, it doesn't look like it's gone over. It was ordered on June 14th. He posted according to the receipt on June 21st. I'm not sure why it's not there yet, but we will follow up and try to get it over there as soon as we can.
Okay, thank you.
All righty, thank you. Court calls the case of the People versus Mason Hurst.
Owen Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hurst.
Your name?
Mason James Hurst.
Today is the date and time set for a competency review, and we don't have an update.
And I don't have a new report.
Likewise.
All right. What was I setting those to? Did I set the last one too?
To August 8th.
Okay. All right. Then what I will do, I'll do the same thing on this one. Do we know, has he met with them yet or?
Not yet.
Well, I don't like putting them more than 30 days out so that we can at least have news where we're headed. So I'll just go to August 8th, 2024, 9 a.m. Unlikely to have a report, but at least we can take.
Thank you. August
right.
8th. Thank you so much.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court does call the case People versus Trevelyan Allen,
Assistant Public Defender Natalie Pate on behalf of Mr. Allen, who should be present via Zoom.
nope, not here.
Your Honor, for the record, I did hear from Mr. Allen via text this morning. We had been playing a bit of phone tag. He did say he was having trouble logging into the Zoom, but then did say he did call in.
That he called in,
He did.
is that a 643?
Yes.
Is his number end in 643, do you know?
If I can look at my phone, it ends in, yes, it does, Your Honor.
All right, Mr. Allen, you called in. You need to hit *6 to unmute your phone. Well,
Hello? Hello?
hello,
Are you
what's
there?
your name?
Trevelyan Allen.
All right, what are we doing on this case?
Thank you, Your Honor. We are respectfully requesting a 2 to 3 week adjournment for further review discovery with Mr. Allen.
And get him to use Zoom. August
Your Honor.
1st, 2024, 9 a.m. He has missed 2 previous drug tests.
That is my understanding, Your Honor. Unfortunately, I did provide that report's information to Mr. Allen. Unfortunately, due to our phone tag, I was unable to have a complete discussion with him regarding
I don't
it.
want any more missed tests, no more missed tests,
Understood, Your Honor.
and he needs to appear in person at the next hearing.
Understood, Your Honor. Thank you.
Otherwise, bond will continue. Thank you.
Thank you, Your Honor. Thank you, Mr. Allen.
Thank you.
Calls case People versus Charles Johnson.
Michigan for the people.
Assistant Public Defender Jay Bellin on behalf of Mr. Johnson, who approaches.
Your name?
Charles Johnson.
Thank you.
And, excuse me, Your Honor, we were just asking to set this matter for examination.
Discovery is complete.
As far as we're concerned, yes, as far as we know.
People have their witnesses available the 23rd.
Yes.
Preliminary examination in person will be set July 23rd, 2024, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the People versus Brandon, is it Bilski?
Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Bilski.
And what are we doing?
Your Honor, Mr. Bilski was released to treatment. At this time, he is no longer in the Oakdale Recovery Program. He did report to Community Corrections. He is signed up with them and is scheduled for an assessment with Dawn Farm on July 15th. We are continuing negotiations with the prosecutor's office and would ask for an adjournment for him to make and keep, for him to keep that appointment.
He has an appointment 15th.
July 15th, yes.
Let's see where they are. Without objection, probable cause August 1st, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case People versus Abdul Sumana. Interpreter
Yes.
coming up. All right. Good morning. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into French and from French into English in the matter now before the court, so help you God?
I do.
State your name.
Joanie Messina.
Thank you.
Can I repeat?
Yes.
Donc, elle représente les gens de Michigan.
John Shea, Your Honor, on behalf of Mr. Sumana,
Donc, lui, il parle en ton nom, Monsieur Soumana.
standing to my right.
À ma droite.
Your Honor, we have received a plea offer in this case, which I believe
On a reçu une offre.
ultimately will
Je
resolve the
pense
case,
que On va résoudre le dossier.
but particularly in light of the language
Par rapport à
difficulties,
la langue, de la difficulté,
we need a week to, we're requesting a 1-week adjournment
on a besoin d'un ajournement d'une semaine.
in order to more fully explain the arrangement with
Expliquer plus
Mr. Sumana,
avec Monsieur Soumana.
so that when he is next in court, he can fully participate.
Probable cause will be adjourned July
Le programme
18th,
sera ajourné au 18 juillet
2024,
2024
9 a.m.
à 9 heures du matin.
And Your Honor, Ms. Hughes has agreed that the offer will remain open
Elle est
until
d'accord
that time.
que l'offre, elle restera ouverte jusqu'à ce jour-là.
That's correct, Your Honor.
C'est bien ça, votre honneur.
All right. Fine, continue. Thank you.
Thank you, Judge.
Thank you. Court calls case People versus Travis Bogan.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Bogan, not with, but Your Honor, may we approach briefly, please?
Not here. Yeah, come on. Oh, hold on a minute. All right, record should reflect we had a bench conference in this case. I will adjourn probable cause conference out to August 1st, 2024, 9 a.m. My understanding is defendant is in treatment. However, because of the previous violation, I'm going to leave the bond that's current or the bench warrant that's currently out in place.
Understood. Thank you, Your Honor.
Court calls case People versus Kurt Kwiatkowski.
Morning, Your Honor. Joy Gaines, Senior Assistant Public.
And you are requesting, well, who is this? How are you doing that? The complaint needs to be amended, I think, because they're supposed, his name is misspelled. Yep, exactly. It should be KWIATKOWSKI, right? Okay. I'll let you run it. All right, very good. And you're requesting a forensic evaluation.
That is correct, Your Honor.
All right. Forensic evaluation is ordered. I'll set a competency hearing for
October 10th.
October 10th, 2024, 9 a.m.
Thank you, Your Honor.
Bond will continue. Here. Then I just need to initial and date. Court does call the case People versus Casey Boyd.
Morning again, Your Honor. Brian Bowling, Assistant Public Defender on behalf of Mr. Boyd. Mr. Boyd? Your Honor, I spoke to Mr. Boyd on Tuesday. I have no explanation for his whereabouts. I expected him to be here this morning.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Woody, is it LaBudge? LaBud?
First Assistant Public Defender Kalina Anderson with on behalf of Mr. LeBud, who's approaching. Please state your name for the record.
Woody Harold, buddy.
Buddy. Got it. All right, what are we doing?
Your Honor, I'm asking for a 30-day adjournment. I'm going to do some referral to the drug court as well as to our social work division. And I'd also ask to briefly address his bond.
Probable cause conference will be adjourned to August 13th. That's a Tuesday. 2024, 9 a.m. Yes, that's the bond.
Your Honor, he's trying to get into treatment. He's hopeful that he can get into Sacred Heart. He would just ask the court to consider a release to treatment provision on the bond.
Any response from the people?
That's why we have to say
So,
that so far.
I am objecting to that. I don't agree to that. Based on the facts of this case, as well as everything that I knew about the defendant at the time that I charged this case, I requested, and actually what I requested was that the court deny bond because it would have been appropriate under the court rule. I asked in the alternative, since the magistrate doesn't frequently do that, I asked in the alternative for $1 million. While I do understand that this person does have substance abuse issues, he was very clear and very direct in his confession to this bank robbery that he was not doing this out of a drug habit. He was doing this to steal money from the bank to get out of the state to go see his father, who he reported as dying. So this is somebody that even if he were to successfully complete inpatient treatment, he would then be out in the community posing a very significant risk to the community. He reported, he wrote on a check, this is the way he robbed the bank, he wrote on a check that he had a gun and he demanded money from the bank teller. And when he confessed to committing this bank robbery and armed robbery, he denied that it was because of his drug habit, despite admitting that he's a daily heroin user. So I don't believe that the treatment for this person would be appropriate because he poses a significant risk to the community independent of his drug addiction.
And Your Honor, I will just state that he did indicate that he did have a drug issue. So he is trying to rectify that part of it. He is looking forward to moving forward with the case. He's remorseful in his actions. He would ask the court to allow him an opportunity to try to get some treatment. It reviewed his record. The only other thing I see on his record are 2 convictions for uttering and publishing. He does not have a background, from what I can tell, of any assaultive conduct, and it should be noted for the court that there was no gun used in this, and there was no gun found on him throughout the investigation.
Of course, the bank people didn't know that allegedly.
No, they didn't, Your Honor, but I'm just letting the court know that he did not have a weapon.
Not saying that I won't release him to inpatient treatment, but at this time, I'm not going to do that.
Okay.
I'd have to have something in, I'd have to see the whole picture of where he would be, under what terms he would be released, but I'm not going to give him a blanket release.
Okay.
So I'm going to deny your request at this time.
If they
His
get
bond will continue.
I can submit that to the court.
Will you help me with that?
You have to do a kite. And if you have problems with that, just call me.
Okay, thank you.
No problem. Thank you, Your Honor.
Thank you. Court calls case People versus Timothy Bracken.
Brian Bowling, Assistant Public Defender on behalf of Mr. Bracken. Yeah, this was a Zoom case. I'm not sure if Mr. Bracken's.
No.
Okay.
I don't have it.
If I may just state for the record, the phone number we have for Mr. Bracken was answered by a place called the Carriage House Ministries Shelter in Flint, Your Honor. I spoke with a gentleman named Craig on Tuesday there. He indicated to me that he was unable to either confirm or deny whether Mr. Bracken was there, but would take my name and phone number and pass it along to Mr. Bracken. That's the last correspondence I had with anybody.
Bench warrant will issue for defendant's failure to appear on 10,000 cash charity. Warrant will issue immediately. Court does call the case People versus Jeffrey Long.
People.
Written on behalf of Mr. Long. Mr. Long, state your name for the record.
Jeffrey Long.
Your Honor, today is the date and time set for the probable cause conference. My client will be waiving his right to preliminary examination and agrees to be bound over to the circuit court.
Sir, is that correct?
Yes.
You're waiving your right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings. You understand that?
Yes, I do.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information. We waive their reading on the record. My client will stand mute at this time.
Defendant, every waive form reading standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
July 24th at 1:30 before Judge Conlon.
July 24th, 2024, 1:30, Judge Conlon.
Thank you very much, Your Honor.
Bond will continue. Thank you. Continue as denied.
This is huge.
Court does call the case of People versus Zachary Burlett.
Ready on that matter, Your Honor. Juan Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Burlett. Mr. Burlett, please state your name for the record.
Zachary Thomas Burlett.
Your Honor, thank the court for the adjournment. We're able to resolve this matter. We will be entering a plea according to the agreement that the court should have.
The court has before it a plea form that indicates defendant's going to plead guilty to the charge of retail fraud, second degree, the 1-year misdemeanor. Upon his second or upon his plea to that charge, count 1 would then be dismissed. There is further the agreement, no delayed or deferred sentence.
That is our understanding, Your Honor. My client is ready to be sworn.
Mr. Burlett, can you raise your right hand, please, sir?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
State your name again for the record, please.
Zachary Thomas Burlett.
All right. Mr. Burlett, it's this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, I do, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, I do, Your Honor.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am currently on probation since June 3rd of 2024.
Okay, but at the time of this offense in February, you were not on probation.
With circuit court, I was, and then
Okay, so you were on probation at that time, at the time of
Yes.
this offense?
Yes.
All right. Then I have to advise you, you understand that this plea could be considered a violation of that probation.
Yes, I do, Your Honor.
All right. And if it is considered a violation of that probation, the court could sentence you to the maximum allowable under that other charge. You understand that, sir?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
All right. Has anybody promised you anything other
No, Your
than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
February 29, 2024, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I attempted to steal a surround sound system from Myers on Carpenter Road.
And the store was open to the public at the time?
Yes, Your Honor, it was.
You didn't have anybody's permission to take that property, did you?
I'm sorry?
You didn't have anybody's permission to take that property, did you?
I did not.
All right. And this property that you took was property that was offered for sale by Meyer?
Yes, Your Honor.
And was the value of that property in excess of $200?
Approximately $189 on sale. It was, yes, under 200, excuse me.
Well, it was under 200, you're saying.
Correct.
Okay, let me ask this then. Had you previously been convicted of larceny 200 to 1,000 in the 80th District Court in Clare County?
Yes, in 2010.
Correct. Okay. In November of 2010, correct?
Correct.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 28th at 9 a.m.
August 28th, 2000. Is he out?
He is out.
He is out.
Yes.
August 28th, 2024, 9 a.m.
August 28th?
38th, 28th. I don't think it has 38 days.
38.
All right, August 28th.
August
All right.
28th. Okay.
28th.
What
He thought I said 38. I don't know. he was, but he'd show up that day, which means we'd never see him again. All right. Okay.
For the record, Your Honor, with the when I was currently on probation when I committed that alleged offense, I am currently discharged from circuit court probation from Collins.
Okay.
I'm on probation by you from June 3rd with Teresa Pilar, I think that's her name.
Pilara, yes.
Pilara, thank you. And she is aware of this situation that happened. So I will.
Oh, yeah.
And advise
She's
her.
aware, and so am I.
Oh, okay.
We
Yes,
got
all-
it. Okay.
What judge is he before?
What judge is he before?
Yeah.
Me.
I'm 28.
You on the 30th of August. Today I created. Did it by order. No, 28th of August.
All right. Thank you, Your Honor.
Thank you.
Thank you, sir.